we will be getting started very shortly. Thank you.
All rise. The Honorable Justices of the Supreme Court and Honorable Judge for the United States District Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court now sitting. You may be seated.
Good evening. Welcome to the special session of the Supreme Court of Kansas. We are very pleased to be holding this session in this beautiful auditorium at Garden City High School. Since 2011, our court has made large efforts to be more accessible to the people of Kansas whom we serve. And these efforts help Kansans learn more about our court and the role of the judiciary in Kansas society. For example, tonight we will not be asking you to participate in a public opinion survey. We will not be asking you to tell us how you think that we should vote on how we decide these cases. But as you'll see, we will be asking the attorneys questions to help us do our job, which is to uphold the law and to make the decisions that the law requires, and not make our decisions based on our personal beliefs or on politics or special interests. We strive to maintain fair and impartial courts in Kansas. Our court has held special sessions in Salina, in Greensburg, Overland Park, Wichita, Pittsburgh, Kansas City, and Hayes. And we have especially liked visiting schools because we have found that our students in Kansas show a great interest in how the Supreme Court operates. Before I proceed, it is my honor to introduce the colleagues who are seated up here on the bench with me. And I'm going to introduce them by their names and their Kansas hometown. And I'm going to start with the jurist to my right. She is the senior on the court next to me, and then I will move down in order of seniority. To my right, this is Justice Marlo Lukert. Her hometown is Goodland. To my left, Justice Carol Beyer. Her hometown is Kansas City, Kansas. To the right of Justice Lukert is Justice Eric Rosen. His hometown is Topeka. To the left of Justice Beyer is Justice Lee Johnson. His hometown is Caldwell. To the far right is Justice Dan Biles. His hometown is El Dorado. And to the far left, next to Justice Johnson, is Justice Caleb Stiegel. His hometown is Lawrence. In order to make an event like this possible, it takes a tremendous amount of planning. And I would like to take a minute to thank all of those people who worked so hard to make this such a successful event. It starts with USD 457 and the superintendent of schools, Dr. Steve Carlin. And I want to thank all the high school staff who assisted with the arrangements for this evening. You've gone out of your way to make this much easier for our staff to help plan this event, and we appreciate your hard work and your enthusiasm. So we extend a very warm welcome to Superintendent Carlin, the school board members of USD 457, and the high school teachers and the staff, and of course the students who are in attendance tonight. This session is being video streamed, so we appreciate the expertise and assistance of the Garden City High School Technology Department, and we thank instructor Jesse Bernal and his students. I also want to thank all the law enforcement and security personnel who are in attendance this evening. I also want to extend a special thanks to our honorary bailiff. This is Judge Donald Blake from Syracuse, Kansas. Judge Blake was appointed a district magistrate judge in 1977. Judge Blake, congratulations on your outstanding service during those many years, and thank you for opening our session this evening. Also want to welcome and thank Chief Judge Wendell Wurst and the judges and staff from the 25th Judicial District for not only helping us today, but also have been working hard to help plan this event. Also want to welcome the Finney County Bar Association President, Zach Schultz, and other members of the Finney County Bar. We are pleased to see so many middle school, high school, and college students with us this evening. As you may know, this afternoon, the justices had the opportunity to visit some of your schools and enjoy their visits with the students and their teachers. Justice Rosen and Justice Biles went to the community college. Justice Johnson and Justice Stiegel went to the high school here. Justice Lukert went to Horace Good Middle School. Justice Beyer went to Kenneth Henderson Middle School. Thank all of you for coming this evening. As you probably know from all the media attention, you are helping us make history tonight. This is the first time since Kansas became a state in 1861 that we have held hearings in Garden City. And this is the first time, any place in our 154-year history of the state that the Kansas Supreme Court is holding an official session in a high school. With your help this evening, this should be a great session. We warmly invite you to a reception in the lobby at the conclusion of our hearings. The justices welcome the opportunity to meet you and to visit with you at that reception. I'm informed that the high school culinary arts class has prepared the food and they will serve at the reception. So thank you, culinary arts instructors Karen Burden and Jacob Huth, for working with your students to plan the reception. I'm now going to call upon Ms. Heather Smith, the clerk of the Supreme Court of Kansas, to do the honor of calling tonight's special docket. Ms. Smith.
Thank you, Mr. Chief Justice, and may it please the court. Appeal number 108963, Betty Bourne et al. Versus Sharon Bourne et al., Sedgwick County, briefs both sides.
Jim Walker present, representing the appellate, ready for argument.
Todd Shadid, representing Sharon Bourne, the appellee, present, ready for argument.
Appeal number 109995, State of Kansas versus Patterson, Sedgwick County, briefs both sides.
Good evening, Your Honors. Assistant District Attorney Lance Gillette on behalf of the State of Kansas, the appellant.
May it please the court, Richard May, on behalf of the appellee, Dante Patterson.
Appeal number 110415, State of Kansas versus Logsdon, Reno County, briefs both sides.
Thank you. Shaman Crane, attorney for the appellant, ready for argument.
If it please the court, my name is Keith Schroeder. I'm the Reno County District Attorney. I'm on behalf of the state of Kansas, the appellee in this matter. I'll be accompanied by Stephen D. Maxwell, Senior Assistant District Attorney, who is also trial counsel.
Your Honor, that concludes the docket.
Thank you, Ms. Smith. Before I call the first case officially on the docket, I did want to announce that there are 3 cases on the docket, and the court intends to take a 15-minute break after the arguments are concluded on the second case. That gives everyone a chance to get up and stretch your legs, and if you choose to leave the auditorium, if you do not care to hear about the third case on this evening's docket, as you probably have read or heard in media, it is a murder case. With that, I'll call the first case on this evening's docket, case number 108963, Betty A. Bourne et al., v. Sharon L. Bourne and Todd A. Bourne et al.
Again, my name is Jim Walker. I represent the appellant, Betty Bourne, on behalf of the Betty Bourne, John Bourne Trust. I'd like to reserve 3 minutes for rebuttal, if that's permissible.
3 minutes is granted. Thank you. Counsel, before you start, if you had not prepared to do this already, for the benefit of the audience, would you give us a 1 or 2 minute factual overview?
Certainly. This is a case that is on appeal from Sedgwick County, wherein the lower court granted summary judgment in favor of the defendant and against my client, the appellant. We then went to the Court of Appeals. The Court of Appeals affirmed the trial court and sustained that order of summary judgment. The case involves a business transaction that was pertaining to the sale of a quarry business. The seller was Sharon Bourne. The buyer was John Bourne Trust and Todd Bourne, later Todd Bourne Trust. The transaction involved less than $2 million. It was structured so that principally no monies were paid up front. It was used with promissory notes collateralized by security agreements. The security agreements were the stock of 2 entities that were the subject of the transaction. The transaction took place in the fall of 2012. 2010, the buyer, John Bourne, got sick shortly after that and became terminally ill and died in September of 2011, more than 4 years ago now. John, at the time of his death, had a surviving widow, Betty Bourne, who became the trustee. She is my client in this case. The transaction contained an event of default, several events of default, most of which were financial events. One event of default was the death of John Bourne. John Bourne died in September of 2011. That triggered an event of default. A notice was given. The parties have been in dispute since that time over issues concerning the notice, issues concerning whether or not an objection was made, issues concerning the tender of the amounts due under the promissory notes, and related aspects.
Counselor, can I simplify this and forget about successors in interest and where we sit right now? We have the first transaction is Betty Bourne, or Sharon Bourne, sold equipment and property to her son Todd and her cousin John's trust. Correct? In the note number 1.
Yes.
Except she didn't sell it to them. She sold it to the LLC that they formed, TJ Leasing.
That's right.
So the parties to that first agreement were Sharon Bourne and TJ Leasing. The parties to that first note.
Yes.
And so your client...
Well, with guarantees.
Yeah, but your client is a guarantor, not a debtor.
That's true.
And the second transaction is between Sharon and now Betty. And that was for the sale of the stock in the stone quarry business.
Yes, up for 50% of the stock in the stone quarry business, yes.
And so the point I'm getting to and want to make clear is that we're going to be talking about pledge agreements. But what we have on that first note is the pledge agreements from the guarantors, not the debtor.
True.
Okay.
What I want to talk about, in addition to answering any questions that you might have today, and use my time to talk about whether or not there was error committed at the trial court level and then, again, not resolved to our satisfaction at the appellate court level. And that has to do with 2 points. One relates to the interpretation of the Uniform Commercial Code Secured Transactions, Article 9-620, that provides the conditions under which a secured party may take collateral in strict foreclosure in the event of default. And our argument on that topic is that the statute says that a creditor can take the collateral in strict foreclosure in full satisfaction of the underlying debt, as applies to this case, only if the debtor does not consent, or only if the debtor fails to object within a timely manner.
I think,
That it does
Say it
consent. First
again.
condition is that it does consent.
Yeah.
Okay, thank you.
Does consent, and if the consent can be the failure to object within the 20-day period from the notice.
Did TJ Leasing object?
TJ Leasing had two partners. One was Todd and one was Betty. We believe TJ Leasing did object. The lawyer representing then Betty Bourne sent a letter containing several conditions and complaints and problems that is a part of the record. And then there was also a lawsuit filed. I think it was on September the 28th, within a very short period of time after the declaration of default. And that lawsuit included TJ Leasing, and that lawsuit included Bourne Stone, and that lawsuit included Betty Bourne as trustee of the Bourne Trust.
but TJ Leasing does not own this collateral. The collateral are units of membership in TJ Leasing. Those are individually owned assets, correct?
Yes, the Bourne Trust owns 51%, and Todd Bourne, later Todd Bourne Trust, owns the other 49%. And the membership interests are what were pledged. But,
Individually.
yes, but it is also true that when the lawsuit was filed, which is a part of the objection in this case, it included TJ Leasing filing the lawsuit as a co-plaintiff.
The letter itself was on behalf of the Board Trust, correct?
Yes,
So
the council letter.
It made no representation that it was on behalf of either Todd Bourne or TJ Leasing.
That's right.
So at that point, there was no objection by those two entities or parties.
Well, there was an objection in the sense that TJ Leasing was in the lawsuit that was filed 1 or 2 days later, was a co-plaintiff at that time.
I think the focus was on the letter itself. It didn't include Todd or TJ.
That's right. The letter was written on behalf of the Bourne Trust.
And we have two individuals here pledging collateral as guarantors of a corporate debt, basically an LLC debt, correct?
Yes.
Can one member, the Bourne Trust, object to the strict foreclosure of another individual's collateral?
Well, the record in this case is that the creditor submitted separate demand letters, separate
My
declarations.
question is, can one guarantor object to the strict foreclosure of another guarantor's collateral?
Well, that guarantor voluntarily surrendered his collateral.
I understand, but my question is legally, is there any basis upon which one guarantor can legally object to the strict foreclosure of another individual's guarantor's acceptance of strict foreclosure?
Well, if they couldn't, what remedy then did my client have would be a question that would occur to me, because Sharon was making a demand on her son to surrender his collateral. And so we were doing the only choice we had with all the authorization we had.
I understand that, which was going to lead me to the next question of if jumping ahead, if you did redeem the whole note, what happened to the other collateral?
49% that was
Yeah,
surrendered?
because Todd didn't assign that to your client. You can't redeem another person's collateral, can you? I mean, the problem we have here is everyone's treating this as if the debtors were pledging their assets. But what it was is the guarantor pledging their assets individually.
Exactly. Yeah, that's right. And
So really, you only had, I'm trying to help you here, the only thing you had legally to deal with is your client, John Bourne Trust, collateral. That's the only thing that Betty had any say-so over, or that she could redeem.
she had 51% of both of those entities. Right. But the court did not, at the trial court level, did not take into consideration at all what the impact was of the surrender of the 49% by Todd. That was never addressed, even though we were at summary judgment at that time.
Was there a record in the summary judgment motions that would have allowed the court to make that determination? For example, were there undisputed facts about value of Todd's interests or any way for that to have been accounted for?
There were.
His interest wasn't zero?
Say it again.
Do we know that his interest, the value wasn't zero?
We don't know if it was 0 or 49% of the outstanding balance. The record did not reach that point. There was no undisputed facts, one way or the other.
So did you argue that summary judgment was inappropriate at that stage of those points?
There were cross motions for summary judgment, and we argued that we were entitled to summary judgment and we were entitled to a credit of 49% against the balance due on the TJ leasing note.
But not like evidence in a record about what the actual value of 49% was.
That's right.
And that's a two-part equation. It's not only the fact, like the district court relied upon minority shares can have a discount, but secondly, we don't know what the value of the company is. We know that the TJ Leasing bought $825,877 worth of equipment from Sharon Bourne, but we don't know what other assets that company had a year later, or whether they had doubled the value of that. So I don't understand how you had undisputed facts under which the court could grant summary judgment for either of them.
Well, I agree with that point that if you're going to take the position that the creditor, Sharon, did not then have to return the 49% if the amount was paid in full, that would be true. If we were going to get a credit for 49% or a credit for some amount for the value of 49%, the record is wanting for valuation evidence with regard to that 49%.
And who would she return the 49% to?
Well, she could return the 49% to either TJ Leasing, and it could own its own membership, or she could return it to the person that was remitting the redemption price, Betty Bourne
Well,
Trust.
back to my original question. That would mean that your client was obtaining Todd's ownership by virtue of redeeming, when Todd himself had the right to redeem at any time.
Well, until he consented and surrendered his membership interest. Then at that point in time, it seems to me he lost his right to redeem.
Counsel, you're out of time. Would you like 60 seconds to wrap up? And during that time, if you can tell us what you're asking the court to do for you and your client.
I want you, justices, to find that Betty Bourne timely objected, has not consented, and that KSA 9-620 does not couple objection with redemption. Those two things are not both required if there is an objection, that she has adequate remedies. And then I also want you to find that this tender that has been declared ineffective by both lower courts really has been weighed or not required by the creditor on the grounds of futility. We say we've been relieved of that obligation because repeatedly counsel for the creditor said, you have to just go through the motions, but you know we're going to reject it. It was very clear that if we were, no matter what amount we tendered, we were still going to be in court. It was never going to be accepted.
Isn't that a subjective viewpoint? Again, are we ready for summary judgment on that point?
Well, I think there's plenty of room to find that that is a question of fact as to whether or not futility applies.
Thank you, counsel.
May it please the court, my name is Todd Shadid. I represent Sharon Bourne, the appellee.
Mr. Shadid, we actually have 4 documents here, do we not? We have note number 1 and the corresponding pledge agreement. And we have note number 2 and the corresponding pledge agreement, which are in essence security agreements in the parlance of the UCC.
Correct.
Where in the notes does it preclude Sharon Stone from accepting payment on those notes?
She will, it doesn't preclude her from accepting payments. There was a right to prepay, the debtor had the right to prepay the notes at any time, and had an obligation to make annual payments.
In fact, there was a prepayment for $375,000 and she accepted that.
On the note number 1, yes, that is correct.
And the way I read it, it has some events of default.
Correct.
It doesn't say they're exclusive events of default, it says events, but then it says in the event of one of those defaults, you can have acceleration.
Correct.
And when you accelerate, that the effect of that, that the note shall become and be in default, matured, and immediately due and payable.
Correct.
It doesn't say collateral shall be immediately forfeited. It says due and payable. So when the debtor is willing to pay off the note, why are we talking about collateral? Collateral has nothing to do with nothing except security payment, to make certain that payment is made. And when you have the debtor offering payment, why are we even talking about collateral?
Well, I would back up and look at the overall transaction and see how it was structured, because you'll see in that note, an event of default does not include failure to pay. The event of defaults are specifically agreed to, tied to either the death of John or Todd Bourne, or the failure of the business, whether it's receiver, bankruptcy, or the operation cease. You look at the closing went, there was no money paid up front. First payment wasn't due for a year. So the way they structured the transaction was the purchaser controlled all the cards. If at any time this business failed before payment was paid off, if you combine the note with the pledge agreement...
But you don't combine the note. So, this talk about the note. My question was, what in the language of the note would preclude the debtor from paying the amount that was declared to be accelerated?
Nothing. And and the debtor had the right to do that under both the note and the UCC.
But your client refused to accept payment.
My client took the position that they would not accept it, but they had the right to tender it. That's the issue. The issue isn't whether Sharon Bourne would accept it. The issue is really the step before that. Did the debtor have the means, or was the debtor ready, willing, and able to tender full payment? Because the choice that the debtor had upon an event of default was either to redeem or pay and get the release of their collateral, or if they thought that the business was not worth what was left to be paid, then all Sharon could do at that point on an event of default was accept the collateral. That was the way the deal was structured, so that it gave the purchaser the option of saying, I don't have to devote any personal assets.
She couldn't accept money?
If they were willing to make that payment. But if they refused to pay, her only remedy was then to go after the collateral.
And what language is it that precludes her from having any other remedy but accepting?
Well,
Are you relying on paragraph 4?
of the pledge agreement, because I think you need to construe the transaction as a whole.
It
And-
says you need to construe the language. It says Stone shall accept the collateral by giving notice of such fact to members, in which case Stone shall forthwith take possession of the collateral. Why does it say in which case if that's not an option?
I'm
The,
not,
the language indicates that she shall accept the collateral by giving notice.
Correct.
That's how she accepts the collateral. And then it says, in which case, then she shall take possession. But it doesn't say shall give notice and take possession. The language itself indicates that that's an optional.
to give notice, and it says she shall give notice.
Shall give notice, shall accept the collateral by giving notice.
And
Shall is how you accept the collateral by giving notice.
right,
And then it says in which case.
when she gives notice.
Yeah, in which case.
Uh-huh.
So that language indicates to me that that's not the only option.
Well, I guess you could interpret it that way, but I don't think that's how the transaction was structured. When you combine it with the note itself that excluded the payment default as an event of default.
So the intent of the party was that if John had lived 5 years and had paid $250,000 on each one of these notes, plus the $375,000 that he already paid, which was 45%. He'd already paid 45% of one note. That the intent of the parties was that Sharon then gets all of the collateral back, even if the company's worth $12 billion.
No, because the debtors at all times had the right to make the payment. They had the choice. She couldn't demand payment for the stock. She could only accept the stock if they didn't make the payment. She couldn't take the stock and dispose of it and then sue for a deficiency. We don't interpret the agreements as giving her that right. She had the right to accept the collateral, and then at that point, everything was done. However, the debtor at any time could redeem or pay off the note and have the collateral released. So the purchaser, the debtor, the John Bourne Trust, controlled the cards because he wasn't investing any personal money to start this business. So if the business went downhill, if the business went out of business, or it wasn't worth what was left to be paid on the note, they could say, take your stock back, we're not paying. And that's all she gets. However, if the company was worth a lot more, $12 billion, of course he's going to pay and take the stock because he gets all the equity. But he wasn't going to get all the debt. And that was the choice that they had, and we believe that they had to then tender that money. Whether it was accepted or not is a different issue. The tendering of it was the issue. Sharon Bourne doesn't control the tender. The tender is on the burden of the debtor, the person making payment, to show that they're ready, willing, and able to make that payment. They attempted to tender because they did tender a payment, but it wasn't in the full amount. And that gets to the other issue about the 49%.
If we disagree with you that there was not a technical violation of the tender rule or whatever, that the debtors really did try to pay. And there may have been a dispute as to the balance on the note. Apparently there was, but they tried to pay the note. Then where do we go? Then what's your position for why you get the collateral if she did try to pay?
I believe, and this may not be a direct answer to your question, so interrupt me if it's not. If there was a dispute about the amount owed, then the debtor has the right under the UCC to demand an accounting. They didn't do that. If they had done that, and you'll see in the Emmons case, if they had done that and Sharon Bourne refused to give an accounting, then you can argue they didn't have to tender at that point because the creditor didn't provide the information to enable them to tender.
That's just telling me that this wasn't right for separate judgment.
Well, I don't...
If there was an accounting that needed to be done because they were in court and they were making the argument that they owed what they tendered because of the 49%. So, they were in court where all of that accounting could take place.
But that assumes two different issues. One, when they made the payment, they didn't provide an accounting or make separate payments. They sent in one check for a total amount and say this is payment in full on both notes. That's one. Secondly, the collateral itself doesn't get credited against the note until it's disposed of, liquidated, proceeds are applied. That reduces the note. The collateral hasn't been converted to proceeds. The collateral was 49%, but if you look at pledge number 1, the collateral is defined as all the membership units. And both members signed that single pledge agreement. So Todd Bourne and the John Bourne Trust both said, we are pledging our units as one. That's the collateral. So even though Todd Bourne gave up his 49%, that collateral still remained collateral, subject to redemption by the payor. And if it was the trust, that collateral gets released per the terms of the pledge agreement and per Article 9 of the UCC. That collateral goes back. Now, if Todd wants to take a position, well, that's my 49%, there's a right of contribution or indemnity for making the payment on behalf of him. So that collateral does not get credited until it's converted to proceeds. And I don't think that leaves it as being a question of fact that wasn't right for summary judgment. I think it goes back to the pledge agreement that doesn't allow this partial satisfaction of the note by giving up partial collateral. That was never contemplated by the parties. It was never, the facts that were in the record don't show that that was ever intended.
But she accepted part. If the pledge agreement said all, she nevertheless accepted a partial. And arguably, since it says full satisfaction, I would have been arguing, hey, we satisfied that she accepted that collateral. I mean, you got to have it both ways. If you're saying it's all or nothing, then how can you take part?
You're holding it until it's paid or not. Because if it was paid, it's automatically released per the UCC and the pledge agreement.
And how do we know, the opposite question when I asked your counsel, when I asked him, how do we know Todd's value is zero? How do we know that what Todd tendered didn't more than fulfill the remaining obligation on the note?
Because I don't think that's a question of material fact that's relevant to the issue, because that, you're assuming that collateral can be split. If the collateral is all the units, it's like you have a security interest in a vehicle, and the vehicle includes these high-dollar rims or an engine. And let's assume you repossess, but it's only the car, but not the engine that was originally with it because it was on a block being repaired. You don't discredit, if they're not disposing of it, the collateral is the entire piece. You don't split that single collateral based on what you find, and then if you do, you dispose of it and convert the proceeds. But in this case, we argue she did not have that right to do so because the parties took away that right. They contractually agreed that she couldn't dispose of the collateral. Why? Because it gave the purchaser the right to control whether he or the trust wanted to buy out when an event of default occurred or when the business went under. If it was worth more, if there was equity, the trust was going to pay it off. If it wasn't, she got her stock back. If the company went bankrupt, that's all she got. There was no right to dispose of that collateral. So it wasn't necessarily a partial acceptance of the collateral or a partial tender. That was just part of the collateral in whose hands that was located at the time and then submitted.
Can we go to the issue of tender?
Yes.
I'm a little confused on how we're using that term. According to my notes, the record establishes that a letter was sent saying basically my client, Betty, wanted to make full payment and Sharon failed to meet with her and refused payment.
That's what the letter stated, but the facts that show after that alleged phone call to which she didn't return the call, there was a letter that said, my client is willing to tender the amount. There was both oral discussions in court by the lawyers and letters. The response to that letter was, we understand that you do actually have to tender, show that you're ready, willing, and able to make the payment. Even though for reasons that we've already explained were rejected, you still have to demonstrate that you have the ability to redeem or pay it off. And it even was an argument saying, we thought you understood the difference because you still have yet to send us a check. And had they sent a check for the full amount, which prudent practice would be pay the full amount, argue about credit later, but at least show that you're able to pay the full amount because the UCC says redemption occurs upon payment of all obligations for which the collateral secures.
Let's go back to that letter, and I want to read something, then ask you to explain it. The letter alleged that Sharon refused to accept full payment on the notes on September 22nd, 2011. Is that a true statement?
I would disagree that it's a true statement. It's my understanding a phone call was made from Betty to Sharon to ask for a return call. The return call was not made. It was never in the record or ever the testimony or admissible evidence submitted in the record that said, I left a message that said, I'm going to pay you, call me back, or that they had an oral discussion that said, I'm going to pay you, and she said no. There was an unreturned phone call. I'm sorry.
So it would be your position that that is not a genuine issue of material fact because that letter is not evidence. Is that right?
That is correct. And the fact that she says, I want to make the payment, isn't actually making the payment. The creditor accepts the payment. The creditor doesn't have any control over tender. So even if she says, I'm going to make the payment, she actually has to produce the funds to make the payment. There was a case that we cited, I think it's out of Florida, that I think both sides cited, I think the Court of Appeals cited, that talked about an attorney wrote a letter that said, my client deposited $10,000 in my trust account, and we're willing to make the payment that we're owed. The payment was never actually made, and the court said, making an offer isn't tendering. Saying you have the money and you're willing to do it isn't actually producing the funds. So saying she intends to pay, which is no different than the subsequent lawyer letters that said we're going to pay, it's not a tender until you actually show that you can pay. Because if they didn't have the funds available, it really doesn't matter because they couldn't pay anyway.
But when Sharon allegedly says, I'm not going to accept the full payment,
right?
Why is that not a genuine issue of material fact that precludes summary judgment?
Because it's the tender that triggers the redemption. And the tender does not require acceptance by the creditor. The statute is pretty clear on this under the UCC. When you tender full payment, then the collateral is released. Whether I accept it or not, whether Sharon accepts it or not, is irrelevant. So I can get the check, Sharon can get the check, if she never catches it, but the funds are good, she can say, I'm not going to accept it. That doesn't change the fact that they've already redeemed it, and they can go to court and say, we've tendered the funds, we've done what the statute said, which is tender, which actually means not only having the ability to pay, but actually producing the funds, and it's over. And it doesn't matter what Sharon says at that point. So her statement saying, I need you to produce the funds, even though you know I'm going to send it back, at least goes through the motions to show you had the ability at the time that you were required to do so to pay the amount in full. They did tender, so it wasn't that they never tendered and said we didn't have to. They did tender. They knew they had to tender. They just tendered an amount that wasn't the full amount, and then later claimed, well, that was because we gave credit at 49% of this collateral that you have not even liquidated, that has no discerned value, to which you don't have a right under the agreements to liquidate in super deficiency anyway. It was our position. It was all the collateral is what we get, or we get full payment. Those are the two options that the parties agreed to on an event of default. And it allowed the purchaser to make the decision that if the company wasn't worth it, the purchaser did not have to pay and can give everything back and not expose personal assets to a debt. And that's how it was structured from the start. That was the intent of the parties. And that
we have case law, and we have statutory law talking about the standards of the right to contract. 9603A talks about standards that are not manifestly unreasonable. You understand that? We have all those cases that I didn't look any up, but I'm sure you're aware of them. The tact was to sell a on an installment contract and put in there that you had strict foreclosure rights. You terminated on one any default, and they could pay 3/4 of, or say 45% of the purchase price, which was done here on November 1, and say you have a default, so we're taking it all back. And we said, no, that's unconscionable. That you can't have a penalty as a remedy. You have to have some semblance of the damages. So why isn't that comparable here? That we have a payment of 45% of the note balance within like 6 months of the note's execution, and 5 months before death, and 5 months later, you get you're construing the agreement that you get to keep all of the collateral plus the 45% payment. Why isn't that manifestly unreasonable?
Well, we don't know what the status of the company was at the time of the event of default, because the company may not be worth anything at that point. If John Bourne is the one running the company and he's gone, that company may be worth nothing. So why would the purchaser then want to pay more good money after bad? That was the whole design. So I don't think that it is manifestly unreasonable.
That same argument could be made on those cases that have the installment contract. The property may be run down, may not be worth anything. So the remedy was the courts fashioned an equitable mortgage. It says we have an equitable mortgage so that, you can take the collateral, but if there's a deficiency, you can go after it. But it didn't allow for strict foreclosure, which takes away, it eliminates deficiency, but it also takes away excess.
Right. And I think you were relying on 84-9-603. And with all due respect, I think where you really need to look is 602, which are the non-waivable provisions of the UCC, of which the strict foreclosure statute is one of them. Meaning that strict foreclosure has certain requirements that give the debtor the right to either consent or object. Or, if it's a consumer good under the installment contract, the debtor or the creditor must dispose of it. The 603 that you're referring to...
No, I'm not getting it. 602 has a right to redeem that's not waivable by the debtor. How does that turn that into a sword for the creditor that they can force a strict foreclosure?
That doesn't. Okay? You have to go back to, I believe, 610, which talks about what rights does the creditor have upon default. They can do 3 things. They can dispose of the collateral by lease or otherwise. They can use a strict foreclosure process. Or 3, they can abandon the collateral and sue for the whole amount. And it says in that statute, may. And if you look at then 602, 610A is not listed in 602, but 610B is. So what that tells you is, if the creditor decides to dispose of the collateral, it must, under B, 610B, do it in a commercially reasonable manner, and that cannot be waived under 602. So if you look at those statutes together, and then look at the parties' agreement, and look at the statute that allows, I think it's in Article 1, that allows everything to be varied by agreement unless expressly stated otherwise, which 602 is otherwise, the parties can contract around the 3 options.
Where are you getting that? Because 601 says after default, the secured party has the rights provided in the UCC, in addition to those provided in the parties' agreement.
Right. So I would go with, first we start with basically the structure of the UCC, which is a flexible statutory scheme that allows commercial expansion through the parties' agreements so that it doesn't have to be amended all the time. So it has flexibility to be interpreted as broadly or as narrowly as the case may be. That's one. And then you look at, I believe it is 84-1-302 of the UCC. And it says, except as otherwise provided elsewhere in the code, the effective provisions of the UCC may be varied by agreement. 602 is the provision under Article 9, which basically says all provisions under Article 9 may be varied by agreement except those listed in 602, and only to the extent that those provisions provide rights to the debtor or obligations to the creditor.
So we're talking passage, I think. The 601 says the secured party has the rights provided in UCC,
right,
in addition to those in the agreement.
Right.
I read you the agreement. It said what rights were in the agreement with regard to the acceptance. Where does it say that agreement say that the rights of the creditor here were only under Section 4? Are you saying in paragraph 4?
Yes.
And if I interpret paragraph 4 as not saying it waived all other rights of the secured creditor under the UCC, then what I'm saying, if that paragraph does not waive all other rights, it says what the rights are with regard to acceptance, but it doesn't say it waives all other rights of the secured creditor.
You're right, that paragraph.
And if it doesn't waive all the other rights, Section 1 says then she has all of those other rights. And if she has all of those other rights, that torpedoes your whole argument, which is founded on the fact that she only had one right.
If you isolate paragraph 4 of the pledge agreement and not construe the documents together, I would agree with that statement. But I believe if you construe the transaction as a whole, by looking at the purchase agreements, notes 1 and 2, and pledge agreements 1 and 2, you arrive at that conclusion because of the way the transaction was structured. But if you isolate paragraph 4 and you kind of read it as if you did, you could say, well, it says she shall give notice in such case she will get the collateral.
Like on note number 2, there's a way that it's structured. It's very common. If somebody dies, I want the share of the stock of that company back. I mean, that's a common scenario because I don't want anyone else running it. And so you have a stock repurchase agreement. You don't rely on a creative interpretation of contracts or UCC.
No,
and that wasn't done here.
No, but usually the restrictions on stock are found in either the bylaws or the operating agreement that says in the case of death, the owner must dispose of it or the other person has a right to buy it. You usually don't find that in the note itself. Those restrictions are restrictions in the operating agreement bylaws.
Can I ask you one quick
Absolutely.
question? I know we're way over time here. Paragraph 8 of the note says, this purchase price note contains the entire agreement among the parties. So, given that, how can we modify the plain language of the promissory note that says upon acceleration is due and payable and doesn't say anything about other remedies being exclusive? How can we modify that through the pledge?
Well, I believe the law in Kansas is when agreements are executed together and part of an overall transaction, they're construed together. And I know it has an integration clause in the note, but I don't think you can then say, well, in that case, you ignore the rest of the agreements that you signed at the same time.
They weren't signed at the same time. Note 1 pledge agreement was September 30th, and Note 2 of the pledge agreement were October 1st.
By their date, but they were overall. It was the overall same transaction at the same time by the same parties. It was the overall scheme of the
It's
entire.
not the same parties. You have Todd's not involved in Note 2.
You know, you're right. Technically, there are different parties, but the owners of those parties are all the same, and it was one transaction. And I don't think there was any dispute to that. And for proof of that, look at the letter that was sent by Betty Bourne when she submitted the check. She should have submitted 2 checks. She submitted 1. And so she didn't treat the parties as different at the critical time of tendering payment. None of the parties did. It was set up, except for the notice that Sharon Stone sent. They treated them separately. At every other juncture, it was one overall transaction. So you construe that transaction as a whole and not take one provision and then, go with it and then create a situation that wasn't the overall intent of the parties. But I agree with what you're saying. In reading that paragraph 4, you could get to that conclusion. And the only argument I would say is you have to look at the transaction as a whole, and hopefully you don't get to that same conclusion when you do that.
In terms of the formation of these agreements, how was your client involved with those? I noticed that it was Board Trust Council that drafted the provisions of the agreement. What role did your client have in the formation of these agreements?
They weren't negotiated.
That's my question.
They were not.
They were the family hired counsel to create this transaction.
John Bourne's counsel, who he had, created the documents to structure this transaction to purchase into Bourne Stone. That was the structure. She was looking to sell to her cousin, keep it in the family. He brought his attorney to come up with a transaction that saved taxes, that didn't cost money up front, and they structured it this way. They drafted the agreements.
And also to secure her interest.
Secure her interest, but limit, we argue, the remedies she had upon default so that it protected John Bourne or his trust if this business went further downhill.
So she had no independent counsel to look at this and to determine whether or not her interest was indeed secure in the way she thought it might be.
Correct. Absolutely right. That's absolutely right.
Thank you.
Thank
Thank
you.
you, Councilman.
And perhaps you should follow up on that inquiry. Does that make a difference here that she didn't have counsel and that your client was basically the scrivener of this deal? Should that be then strictly construed against Bourne Trust and John Bourne?
I think that's what's been argued by the defendant throughout, and
What's
it
your
is
answer?
true.
What's
It
your
is
answer?
true. Yes.
Okay.
Counsel, what reason, if any, was articulated by Sharon to Betty when Sharon essentially said, "I'm going to reject any tender that you make"? Was there any reason articulated?
Not that I know of. One of the differences here on this notion of tender and rejection that has not been articulated yet is the fact that none of the cases that counsel has talked about concerning the obligation to tender, in none of those cases does the reported record or the decision disclose that the creditor was saying, "I'm not going to accept it. You have to go through the motions. You know we're going to reject it." The South Fork case that he referred to in his argument has none of that language in there about the creditor saying in advance, "We will reject it. We won't accept it." So I think that's an important difference. We also think that, as noted by some of the questions, Sharon did not have only two options, as I think the Court of Appeals indicated, namely accepting full payment of all the obligations or strict foreclosure. The UCC, I think, discloses that she continues to have the option of disposing of the collateral in a commercially reasonable manner. That option still exists, even though it was not in the document. It's a non-waivable provision under the UCC, and we think that still exists. Any other questions?
Do you have any further questions? I see none. Thank you, Counsel. Thank you both for your arguments this evening. The Court will take this matter under advisement. Now, turn to the second case on this evening's docket. Case number 109995, case Kansas v. Dr. Patterson.